All right. Well, welcome everyone. This is a webinar today that we put together related to the roadmap for climate reporting related to California, specifically greenhouse gas emissions and climate risk reporting. Hello and good morning or good afternoon, depending on where you're tuning in from. My name is Steve Stewart with SCS Engineers. I'm the Director of Sustainability here at SCS and excited to be hosting this event and being the moderator for today's session. So we're here today to talk about some relatively new requirements out of California related to climate, which includes, like as I mentioned, greenhouse gas emissions reporting as well as climate risk reporting. So these requirements not only apply to companies that are situated in California, but also companies that are outside of California that are what we call quote unquote doing business in California. So today I'm joined by two experts, one of which is our SCS's National Climate Practice Leader, having over a couple of decades of experience in greenhouse gas inventories as well as climate reporting. Victoria Evans, good morning. How are you?
Good, thank you.
I guess I should also note that I'm joining you today from Alabama. If you haven't figured that out yet by my accent, right? I may throw in a couple of y'alls for you, but I won't be charging extra for those. Whereas our other two panelists are joining us a few states away in California. So our other panelist, David Smith, a partner at law firm of Mannett, Phelps and Phillips, where he advises on complex entitlement and regulatory compliance at all jurisdictional levels. He often counsels on leveraging federal and state incentives and regulatory mandates. Welcome, David.
Thank you very much. Happy to be here.
So started. So I've already introduced our panelists today, but I also wanted to share this disclaimer with you all that this information and opinions of our presenters don't necessarily represent those companies that employ us. And so in some cases they are strictly opinions, so don't hold that against us. So our agenda today includes some background and context. We're going to touch on Securities and Exchange climate disclosure that was, I guess, rolled out last year sometime, and we're have a deeper discussion on what California's requirements are, and then the roadmap for completing what those requirements are, and then also some takeaways, and then hopefully we'll have some Q&A at the end. And so sit back, enjoy the ride. We appreciate your attention and participation. So at this time, I'm going to turn it over to Victoria. Victoria?
Yes, thank you, Steve. So bear with me today in my voice. My allergies are happening. So the laws and regulations that we're going to talk about today are game changers, and they're game changers because they require a new type of climate reporting focused at the corporate level. So this first slide's goal is to show you a quick history of where we've been with mandatory reporting for climate for both greenhouse gas and climate risk. Mandatory reporting history for climate started with the focus on emissions of greenhouse gas emissions for individual facilities, and you can see this in the slide. And you can see that it officially began about 20 years ago in 2005 with an initiative in the northeastern states of the US. At the time, this reporting was linked to climate goals that were set in the late 90s and early 2000s for the reduction of greenhouse gas emissions and therefore of climate impacts. And these goals, in many cases, were formally established by several states. Some were set forth in legislation. So to implement the reduction goals, these early goals accounting of greenhouse gas from industrial facilities and power generation facilities was a key focus. So this reporting became an important element of programs that were incentivizing greenhouse gas reductions for cap and trade, or similar programs like those adopted by RGGI, the Regional Greenhouse Gas Initiative in California, Oregon, and Washington. So noteworthy, a shift to a corporate focus for climate disclosure formally started in the United States, at least in 2010, when the SEC adopted a voluntary corporate climate risk disclosure recommendation, in air quotes, based on investor and consumer interests primarily. So we find ourselves 13 years later in 2023, California adopts two climate laws after 2 years of debate and after another year for the amendment to each law. So from the state perspective, California led the way. In 2024, SEC finalized their sweeping rule, their new rule for climate disclosures for mandatory climate disclosures of greenhouse gas emissions and climate risk for public companies. So that was 2 years in the making, as we all know, in the rulemaking process, and we'll talk more about this later. So what's important also about this slide is there's 5 states with the emerging requirements, and these are mostly copycats of California's law. So interestingly, as of March 2025, New Jersey, we can add them to the list. But Washington, New York, and Illinois have laws under consideration in 2025 that are copycats for greenhouse gas reporting. They're copycats of California's SB 253, which is the greenhouse gas reporting requirement. New York has an additional law under consideration that is a copycat for California's climate risk. And the Minnesota law applies to banks and credit unions. Excuse me. So for this slide, we are, what came before all this mandatory reporting is voluntary reporting by corporations for over a decade. And we wanted to show you in that slide here, this reporting continues today. And for the CDP, it shows the increase in this type of reporting over time. And just know that the current number for the SBTI reporters in 2025 is almost 10,000 companies. Sorry about that. So as we've developed from voluntary to mandatory reporting for this corporate level type reporting, it's important to note there's a constellation of frameworks and standards, raters and rankers of the global corporate goals and principles, and then of course of regulations and legislation. So importantly, the frameworks and standards, some of which are noted here, the primary ones, are relied upon and referenced in the legislation and regulations across the globe. So there's high-level guidelines like TCFD and their successor, the International Financial Reporting Standard for climate-related financial risk reporting. And there's protocols with specific tools and methodologies, such as the Greenhouse Gas Protocol. And I can tell you, I sit on the Global Technical Working Group for the Greenhouse Gas Protocol, and we're working feverishly on revisions to that guidance. So, and probably many of you are aware of this, there'll be clarifications and guidance put out for public comment coming up for Scope 2 emissions in 2025, and for the corporate standard as well, and Scope 3 guidance in 2026. Excuse me, the corporate standard revisions will come out proposed in 2026. So the raters and rankers include CDP that you heard me reference before. There's many others that aren't listed. They review submittals and provide their view of ranking of individual companies. This information is used by investors and consumers. So the regulations and legislation that we'll talk today are the mandatory climate disclosures required by governments and regulatory bodies. And today we're going to focus on the SEC in California. But notice that the EU requirements are also in place under the 2 blue circles that you see on the chart. And outside the US, we have Canada, who's requiring reporting of corporate climate risk, greenhouse gas, and ESG metrics. We have clients who provide services to those companies outside of the US and have already received questionnaires from the EU and Canadian customers. And something to look forward to possibly for us and others is Mexico. Mexico's SEC equivalent agency has a new rule for reporting of corporate greenhouse gas and ESG. We can move on. So I just put this slide in case we need a quick reminder. This group's pretty knowledgeable about greenhouse gas emission categories, but needless to say, scopes 1 and 2 are easier because they're direct, and really scope 2 is indirect, but those are corporate emissions that are traditional and we're all sort of used to, but it's the scope 3 that's really the value chain, the supply chain. And there's 15 categories of that, of scope 3, and it's pretty detailed and involved, and it can take up to 2 years or so to get that together. So I'm going to now hand it over to David Smith to take us through the SEC and California laws for climate disclosure.
Thanks, Victoria, and thanks again for having me. It's great to be here with everybody. Steve, will you do me a favor and go back 2 slides to the ones with all the icons? I just think just a little context setting from, I speak pretty regularly on this stuff, and one of the things I've discovered is there's absolutely no middle ground. Either folks have been involved with this and done it for decades, a la Victoria's first slide, which was, much of it was just a tack onto industrial operations reporting that was already going, and things like cap and trade at RGGI in California hit folks who were already used to heavy regulation of emissions. And this, I don't mean to minimize this, but it was a new thing. The rest of the world, and there were some that were frankly guilted, big retailers, big corporate responsibility folks that were guilted by the Carbon Disclosure Project, among others. And you see that icon down at the bottom. See, they've now go under CDP. But basically said, you're selling stuff to the world and getting rich, you should be telling them what emissions are behind that. And a lot of industries that weren't subject to industrial emission reports started voluntarily putting their numbers out there as best as they could estimate them. My point in raising this is we probably have some in the audience that are, yeah, I understand. Others that are, where did this come from? I have no idea what you're talking about. You're not atypical. This is the world. And the biggest driver, I think, to bringing people in that haven't seen it before is shockingly the investment sector. A lot of this started with the investment sector. We talked about scopes 1, 2, and 3. What a lot of folks don't realize is at investment banks, financial institutions, there's 15 categories of scope 3 emissions, and the 15th category is called financed emissions. So banks and investment funds are very shocked to realize that whatever money is going to investing, those are also their scope 3 emissions. So I love this exhibit. Commend, it's all Victoria. These acronyms, I thought in my 30 years of legal practice, I had seen it all. And we're not going to do a deep dive, but just be aware in this era, this new administration, not just impacting America globally, you're seeing a big pushback in Europe to downshift on their regime called the Corporate Sustainability Reporting Directive, CSRD, is under debate now for a pretty big scale back in terms of 1, who it applies to, and 3, the scope of disclosures. So anyway, a lot of what we're going to talk about is in flux, but this is a great exhibit for acquainting with the crazy world that we're in. So the SEC, as you may, spoiler alert, is as good as dead, given the change of administrations. But it really started the whole thing, so we are going to discuss it. And when I said dead, it doesn't have a stake in its heart just yet, but it's in litigation. And what the Trump administration has stated outright to the court now is that they will not defend the lawsuit, which means nobody's fighting for this rule. And even if it were to prevail, the current administration would probably take steps to repeal it. So proposed in 22, finalized in 2024, given that it's not, we would normally do a deep dive in the evolution. Federally, if an agency wants to propose a rule like this, they have to draft the proposed rule, put it out for public comment, and you get robust feedback. The SEC got more feedback on this rule than in their entire history, by far, exponentially more, tens of thousands of comments. And so it took them a long time to issue the final rule. Like I said, the procedure is not as important given where it is now, but the content is. So there were 2 major parts to the SEC rule, and the reason I'm breaking them down is it's going to track with the California legislation that we're going to talk about. So the first is disclosure of greenhouse gas emissions, just the greenhouse gas protocol, scopes 1, 2, and 3. Well, the proposed rule included scopes 1, 2, and 3. When the final rule, after review of the public comment, came out, I think for political considerations, frankly, I don't know how they expected one little tweak like this to eliminate the political considerations, but maybe they thought they would avoid getting sued. But the SEC dropped, and this was prior to the Trump administration, dropped scope 3. So, but it was still significant enough for the Chamber of Commerce and the Farm Bureau to sue over it. But when they dropped scope 3, the Sierra Club and NRDC also sued on it. They ended up dropping their lawsuit pretty quickly, which we'll get to in a second as to why, which is of concern. The second one is a regime, and we're going to talk about this more comprehensively in California, of climate-related risks. The climate emission disclosure is a numeric, quantitative disclosure of math and numbers and what are you admitting, and we can check your homework and see if we believe the numbers or not. Climate risk is a narrative qualitative disclosure. California has a specific regime I'll mention, but the SEC provided its own regime. One of the big concerns about all the multinational reporting regimes is consistency. If I have to do this, I'm not making this up. I was just consulting with a client. They've been giving pretty extensive disclosures to Japan for a very long time, and they want to know if what they're disclosing to Japan is going to qualify for California, and the answer is probably not, at least initially, but we can get into that. So the SEC, in one rule wrapped in the emissions disclosures as well as the climate risk disclosures, pretty immediately sued upon, like I said, and the Trump administration is not going to enforce it at all, or is not going to fight to defend the litigation at all, which means one way, shape, or form, it will die. We do note there at the bottom, there is existing 2010 interpretive guidance, which is certainly not irrelevant. It doesn't establish a new rule, as the title of it suggests. It rather says under existing disclosure obligations for publicly traded companies, some of the material factors that would be relevant to investors may include environmental issues such as greenhouse gas disclosure and climate risks. Now, I just want to put a broad overlay over this on the federal level. Again, we're going to talk about size of companies in California. The SEC rule would have applied to any publicly traded company, regardless of size. So that's going to go away. California will talk about applicable. So we talk about what rules require these disclosures. There's always an underlying thing. If you choose to say something publicly about your commitment as a company relative freestanding to yourself, or sort of insinuating why you're better than your competition, you're now subject to being called out by the FTC and others, sort of a truth in advertising thing. And you've probably heard the term greenwashing. That's what that's all about. You may not be under a formal legal obligation to make the disclosure, but once you're claiming a net zero pledge or reductions or the greenest or the most sustainable, you are subject to enforcement to have to prove why you're using that terminology and what you're doing to further it. So let's shift to California. When it was in I'm out in California. Once we were in the midst of the SEC rule and there was some uncertainty whether scope 3 was going to be dropped, stay in, a lot of political bantering. That only, as it tends to do, kicks California into high gear, and we are going to prove to the rest of the world, not only can this be done, it has to be done. And as anybody else suggests, backing off only gives us all the more encouragement to speed up. So this legislation, and we'll talk about, it's two bills, one mirroring the SEC, not exactly the same, but topically. One is emissions disclosures patterned off the greenhouse gas protocol, which you heard Victoria reference. And the other one is climate-related risk, which is tied to a regime called the Task Force for Climate-Related Financial Disclosures, TCFD, which has now been rolled into another acronym, which Victoria knows I don't, and we'll leave it at that for now. But we'll talk about that regime. When the bill was pending, it was the second go around in the legislature. And people just said California in all its glory. Yes, it loves to lead the way environmentally. Even this is a bridge too far for California. It's a burden on business. They're not going to do it. They're not going to pass it. Well, sure enough, they passed it. And I told them they would pass it. And then they said the governor's not going to sign it. It's too much of a burden on business. He's not going to sign it. I said he's going to sign it. And as it turns out, not only did he sign it, he jumped on a plane with a greenhouse gas footprint, by the way, flew to New York for Climate Week, stood on the steps of the UN in the midst of Climate Week, waving around the bills that had been passed by the legislature. He hadn't signed them yet. It wasn't his deadline to sign them yet, and pronounced to the world, I will be signing these. California, again, is leading the way. What is wrong with the rest of the world? You need to catch up and start doing this. So all the poo-pooing that he was not going to sign, not only did he sign, he grandstanded and put it all out there. Ironically, then, when the presidential campaign became a little dicey and his name was being kicked around, he talked about delaying them for 2 years, which we'll get to in a second. Anyway, so the two bills, 253 by Senator Wiener, who his name is important, just tuck it away in the back of your mind. He's since elevated to chair of the Senate Budget Committee, which is a very, very powerful position. And he and the governor do not always see eye to eye. But in his position there, he has a lot more leverage than he used to. And he's a very prolific legislator, very involved in a lot of things. So SB 253 acquires any company that fits the criteria, and we'll set the criteria in a second, to disclose publicly all emissions, scope 1, scope 2, and scope 3. And as you can imagine, once the SEC dropped scope 3, there was pressure, and Senator Wiener took to a microphone and said, all the more reason California has to require it, because without scope 3, these disclosures are meaningless. That's subject to debate in the community, but rest assured, scope 3 is there and central and is not going away. So who is required to, actually, sorry, go back. Who is required? There's two criteria. One, doing business in California. And we'll talk about that. Victoria will talk about that. But think of an inverse relationship as they wrote this. They wanted the most inclusive possible hook. If you fly over California enough times, you're doing business in California. Okay, not exactly, but pretty darn close. You do not need a physical footprint here. Do you transact financial business here? Do you have lawyers here? Or is paperwork signed here? Obviously, if you have a footprint here, you're doing business in California. It is a very small, your activity needs to be very minor to be hooked in under doing business in California. And that's going to be vetted out in courts. But I can tell you the author's intentions was to catch as many companies as it can. Now, the second one, a lot of people sort of roll their eyes and say, why are we even talking about this bill? It is a $1 billion annual revenue threshold. Now, while the hook of doing business in California is very small, you don't have to be doing a lot to go. Once you're in, the scope of your disclosures and calculating that 1 billion is wherever you are in the world globally. It's not limited to what you're doing in California. So very small hook, get you hooked in, and then your reporting obligation and whether you satisfy the revenue criteria is absolutely everything you do. So you can see that dichotomy is ropes in as many as possible. Now, if you say, I'm absolutely nowhere near 1 billion in revenue, so I don't need to worry, the question becomes, are you doing business with anybody who might be? Because those, whether voluntarily reporting scope 3 emissions or become subject to this mandate to disclose their scope 3 emissions, historically, we've relied on a lot of modeling for those calculations. They don't like modeling anymore. They want actual data. So we are seeing increasingly, both in real estate transactions and retail sales contracts, supply chain contracts, obligations to provide real world data of what your greenhouse gas emissions in producing whatever it is you're engaged in commerce related to, so that the ultimate disclosure person entity can give accurate information. The disclosure obligation is scopes 1 and 2 are due in 2026. In his gracious eminence, Senator Wiener, the only give he gave during the very contentious legislative negotiations on these, when he was pressed to drop scope 3 and do other things, he refused adamantly, but he did give a 1-year reprieve. The scope 3 disclosures are not due until 2027. Now, a little more palace intrigue. As it came close to these being due, the governor, unbeknownst to anybody, frankly, and some of us discovered it because we track very closely, in his budget, quietly and secretively proposed a 2-year delay in the effective date of both 253 and the next bill we're going to talk about, 261, without even consulting Senator Wiener. Senator Wiener was not happy about that. And it would have required a legislative amendment to do that. And Senator Wiener said absolutely not. In a nod to him, they did extend the obligation for the California Air Resources Board to draft implementing regulations from January 1, 2025 to July 1, 2025. They haven't even started. They haven't hired staff. If you talk to people at CARB, California Air Resources Board, it's a given they're not going to hit that deadline, which casts all kinds of uncertainty over this. But in terms of disclosures, you cannot count on that going away. I will also note, just because I can't remember whether we raised it in a later slide, a lot of people are taking a reprieve and a deep breath because CARB recently released a notice of limited enforcement on the initial round of disclosures, which also upset Senator Wiener tremendously. He sent a nasty gram with some other powerhouse hitters from the legislature to the chair of CARB saying this is not okay, but they had already issued it. Basically, they said for the 2026 disclosures, as long as you make a good faith effort, we're not going to come down hard. Read into that good faith effort, because Senator Wiener is going to want to make a poster child of some entity that's obviously covered and wants to avoid it. Thank you. On 261, so the second area of disclosure is, again, the narrative qualitative disclosures of climate-related risks. I give you the statutory definition of risk there simply to show you how broad it is. I'm not going to read through it, but I encourage you to notice in the first line, material risks, disclosure of material risk. We're going to camp on that in a second. The hooks are the same that I mentioned, doing business in California, same whatever that means. And the revenue threshold is only 500 million. Next slide. And so it's tied to the Task Force for Climate-Related Financial Disclosures. The due date on the face of 261 is January 1st, 2026, which means you're supposed to be assessing your climate risks right now and be ready to provide a full disclosure on January 1. That's not going to happen in all likelihood, and CARB will probably address that if they ever get around to writing regs. I think it was just inartful drafting in the legislation that they put the deadline. I think they meant to say it's effective January 1. But if you read on the face of it right now, a lot of interpretation is your first report is due. I think they're handling it that it'll be due in 2026, but that's not what it says right now. So stay tuned on that. The materiality reference I made earlier, you have a bit of discretion to your company whether it's financially material to whether someone would want to invest in your company, and you can interpret that broadly, but not as broad. In the EU, they have what's called double materiality, where you have to not only disclose financial risks, but also potential environmental risks.
So beyond the annual revenue threshold for public and private companies in each California law, there's this additional applicability consideration that you've heard David talk about. And this would imply there's some criteria for doing business in California. And as noted, it's not defined in either law. And so this leaves us with no criteria unless we look at what the California Franchise Tax Board says is the definition of doing business in California. So these are the numbers for 2024. In terms of specific dollar amounts, but as well, the Franchise Tax Board has these additional criteria. If you're considered to be doing business, if you meet any of the following: engage in any transaction for the purpose of financial gain within California, or organized or commercially domiciled in California, or your sales property or payroll. Dollar amounts exceed the numbers in the table. So we wanted to make sure we talked to you about this. This has come up multiple times. I'm now going to invite David Smith to comment on this, because this is this topic is out there right now as it's not completely resolved.
So in my former life, I was a journalist prior to going to law school. So I'm always very digging into the details and not just the legalities, but the intrigue and the politics and the policy behind it. So number one, there is no qualifier in the legislation tying it to the Franchise Tax Board. It is the same language. It was not discussed in real time as the bills were being debated, but several have raised it now. How I am counseling my clients, I know the views of the authors, which do not necessarily govern. We've talked about, Victoria and I have talked about this, the relevance of it. It's what's called persuasive authority. If it will come to a court, what doing business in California means eventually. And the court may be interested in things like what the author said about the bill language and what was amended and what wasn't. What they rule on is the language of the statute itself, regardless of what anybody says and the appropriate interpretations of that. If there's some gray area, they reach out. For purposes of advising my clients now, because I know what the intent of the statute was, you have to assume it's the broadest possible interpretation. They will rope in as many people as they possibly can. And I would argue that even if they go with the Franchise Tax Board definition, that first bullet, engage in transaction for the purpose of financial gain within California, I would say I don't believe it's the correct interpretation of that based on its plain reading, but I think if you decouple financial gain and within California, that can be read as, which the authors probably would read it as if they were forced to be tied to the Franchise Tax Board, engage in any transaction for the purpose of financial gain, period. Oh, that happens to have that hook in California. It doesn't necessarily have to mean that your financial gain occurs in California. Maybe you contract with a supplier in California, but the assembly and sale of whatever the ultimate product is in Minnesota. Okay, you're not financially gaining in California, but if a piece of the equipment is manufactured in California, which it's probably not because it's too expensive here, but anyway, you get my point. I understand this. I see the similarity in the language. If you are taking a conservative perspective of whether you are subject to this law, and you're trying to carve out some level of transacting business in California, I would just say tread very carefully, because I think the intention will be to be in California if you've got any activity whatsoever. Don't invite me to your next party.
Let's go to the next slide. Thanks. We wanted to provide a slide that shows the updated timelines that we've talked a little bit about earlier in this presentation. So the regulations due date for CARB to issue their set of regulations for greenhouse gas emissions reporting was delayed till July 1st, 2025. These are the changes that were made in the amendment to each of these bills. So we've talked about the requirements for annual greenhouse gas reporting that are due in 2026. There isn't a date that's been set by the CARB, by the California Resources Board, as to what date that is. If those emissions that are to be reported on, which is what the law talks about for 2025, those of us that work in this field would tell you, you can't do that by January 1st, 2026 for 2025. It doesn't work that way. Half the time we don't have the bills for 2025 for quarter four. So that would need to be adjusted forward. That would be typical because we do other reporting on environmental parameters as well. And those are typically March or April type due dates. So consolidated reporting at the parent company level was allowed under the amendment. This was asked for and requested by apparently several companies, and the authority to CARB to set the reporting due date for scope 3 was included in the amendment. And then there's no change really to the biennial climate risk disclosure due date starting in 2026. So that's, I believe, all I wanted to hit on this one. Let's go back to David for some discussion of litigation.
So this is a very hot topic for a lot of people, counting on the fact that the litigation against the California laws will step in and force them not to have to make these disclosures. I am just not bullish on that strategy, unfortunately. So one note I wanted to get, I hinted at it earlier, as to the SEC rule, which I think is relevant in California as well. So we talked about the difference between greenhouse gas emission disclosures, which are numbers, math, science, verifiable. You turn in a report, and someone who thinks you may be not being fully accurate can, again, check your homework and see if they believe the numbers or not. The risk disclosures under TCFD, again, are narrative and qualitative. I always choke on the distinction there. And so a lot of people don't have as much heartburn in terms of a good faith effort and trying. I mean, we represent a major national retailer with pharmacies. I won't say the name, but you can guess that there's not a whole lot of them. But they have over 9,000 retail outlets. And having to quantify which ones have climate-related risks and not, and why or why not. And by the way, you're not just disclosing the risk, you have to disclose what it is you're doing about it. My point is on those who took lightly, because again, they're narrative and qualitative, not numbers that can be checked. When the Sierra Club filed suit against the SEC for dropping scope 3, they pretty quickly dropped their lawsuit, which I think was smart, because I think it's pretty hard to force the SEC to say you have an obligation to include these. You can say you should for a reason, as I know someone has commented in the side, and I understand. They dropped their lawsuit pretty fast, took to the microphones, held a press conference, and said, we instead will be devoting all of our resources to ensure that the climate risk disclosures are credible and enforceable. Once they fine-tune that and figure that out and start enforcing on climate risk disclosures and whether people are appropriately gauging materiality and things like that, that will be a significant compliance hurdle. So I just throw that cautionary note out. Anyway, the current lawsuit against the California bills 253 and 261. One, notice, while it's a California law, this is not the California Chamber of Commerce. They're in it as well. But the national organizations were significantly upset about this enough as a precedent that the U.S. Chamber of Commerce, as well as the American Farm Bureau and a bunch of others, are the ones suing over this. The lawsuit made 3 major claims, 2 of which have been dismissed with as not having any merit. The third one is basically a First Amendment argument that you're compelling companies, which are covered by the First Amendment, by the way, to make statements that they're not inclined to make, and that may be speculative and non-verifiable. And they say that's a violation of the First Amendment. First Amendment not only ensures your ability to speak, it also ensures that you're not forced to speak on things you don't want to. There is a hearing coming up in May that could result in a preliminary injunction against the enforcement of these laws. And a lot of people are counting on that sticking. Again, I'm not bullish. I will say outright, though, I don't think CARB would be upset if a preliminary injunction went in. I will also say I don't think quietly Governor Newsom would be upset if a preliminary injunction said. Publicly, they're not going to say that. And in fact, as we're seeing, Governor Newsom is responding to a lot of Trump administration activities, just the opposite as they tend to do, including on climate, and saying we will continue to blaze the trail. So you'll hear just the opposite from him. But I'm concerned because, one, there was already, for the legal wonks, there was a motion for summary judgment on this, which did not prevail. The judge didn't rule no, but allowed for some discovery, which is going to delay things somewhat indefinitely. But for the preliminary injunction to stick, they have to find imminent harm. It's a facial challenge, which means they challenge it as to it can never, ever, ever be applied constitutionally, as opposed to an applied challenge where it's just difficult. So we'll be watching closely in May. I'm not optimistic that it's going to go on ice, but we'll see. Victoria, back to you.
Thank you. Thank you, David. It sounds like one of those TV shows. So now we will pivot from the legal to the practicalities of what's next. So we prepared a couple slides with some outlines of roadmaps that are intended to show you what to do that is to get to the finish line. So I'm going to just start and make a couple of time considerations in terms of how long this effort will take, because we didn't include that on the slides, in terms of the time it will take to get to completion. So David and I have talked about this, and we each have experience with clients. The bottom line is this depends on the size of the firm, and in terms of the number of offices, the number of stores, the facilities, and the number of employees, and the number and the complexity of the company's operations across the corporation, itself. So if you're starting from scratch, let's say it can take at least 12 months just to get through the process for each of the risk and greenhouse gas inventory efforts. They can run simultaneously side by side, but there are some feedback moments between the two, certainly between the inventory at the corporate level in terms of considerations of that inventory within the risk assessment. So that's our pitch on that. So then in terms of the roadmap, these are the steps. I have a couple slides here. This is for greenhouse gas emissions reporting. These are the top 3 here in terms of getting started to establish governance and data practices. And because now this is mandatory reporting, it's important to have a governance structure with the responsible team and accountability to simplify your data collection. It's really easy to say that, but harder to implement. So we've tried to include the recipe here in terms of how to get to the finish line with the least bruises and cuts along the way. So, and one key part about this, number 1, is to set up the processes to ensure your data quality is great so that it can be verified and you have a record and you're ready for an eventual audit. In this case, there'll be limited and reasonable assurances required for this type of numerical reporting. So assess and fill your gaps in 2025, and we're seeing this in April. So we're hoping people have been working on this and make a good faith effort for reporting for the emissions in the first round. So then in number 3, screen for your scope 3 categories. Why would you do this now? It's because it takes a long time to do scope 3. There's 15 categories that you have to look at and rule in or out as to whether they're appropriate for your company. So I'm recommending here to map them to corporate activities, get started early, figure out it's not just what activity data you have, it's which ones apply to you in terms of what you're going to have to calculate eventually and demonstrate. We can move to, thank you. So for climate risk, let's we're recommending review those requirements and standards, become familiar with those. This is real different than numerical reporting that David's talked about, and you're hearing from me too. This is not the same thing, but there are numbers involved and there are financial and other considerations. But again, there's 4 themes: governance, strategy, risk management, and metrics and targets. And guess what? The metrics and targets and climate risk reporting include, yep, we're back to the corporate greenhouse gas inventory and the IFRS. I do have the wrong acronym here. The International Federal, anyway, so the IFRS standards include the corporate greenhouse gas inventories for all 3 scopes. So again, you're to report for 261 to the best of your ability and explain any gaps and how you're going to fill them and report on that in the disclosure. So we're suggesting assessing and filling gaps in 2025 and then creating a plan to fill those gaps because you have time to do that before the next reporting cycle in 2028. So our key takeaways for today, you've heard us talk about this. The corporate climate disclosure requirements are part of a global trend. And the ability of U.S. firms to respond to this is a key factor to remaining globally competitive. And we're working with clients ourselves now who feel this in many cases, and they're medium to small firms, for example, who aren't involved in the California program, but are affected by these other global requirements. So here to talk about both these laws will impact over 10,000 companies in total in the U.S. for both public and private firms. The new state legislation that's occurring in these other states echoes, and you heard me call them copycats, California's climate requirements for both greenhouse gas emissions and risk reporting. So the California laws, they do cover annual reporting and assurance for the greenhouse gas emissions, and along with the climate risk reporting, and it's really a disclosure at the company's website. So the CARB enforcement notice from December 24, I encourage folks to reread that if you haven't, read it for the first time. It does specifically apply to the greenhouse gas reporting law. It doesn't necessarily address 261 for risk. It says no enforcement efforts will be made if companies demonstrate good faith efforts to comply, which is why you see us encouraging that. It's not a pass to skip the first year of reporting for greenhouse gases. And you heard me say it does not apply directly to 261 for risk. So 2025 is a critical year to assess your readiness and to prepare your compliance plan and to take action to put yourself in the best possible position. So thank you for your kind attention.
Thank you, David and Victoria. Great presentation. One of the first comments has to deal with scope 3 and related to the SEC taking it out of the requirements there. I think the point that the question is making is that if we're in agreement with the Paris Agreement, the 2 degrees or 1.5 degrees Celsius there, does it make sense to take out scope 3, even though there's a lot of, I guess, question marks about how to go about it, and and what's your opinion on that?
Did we lose?
No, Victoria, go ahead.
Okay, I was going to just say the issue that we're looking at here today and that we encourage clients to look at is, what do you have to do under regulatory requirements? And that's why you hear us emphasizing the sequencing of doing the work to get ready for it and when the reporting is required. So if scope 3 is on a delayed timeline for reporting, on a requirement basis, but scope 3 for companies that have already committed publicly to reduce their emissions, most of those companies, for example, have already been engaged in this and doing their scope 3, and they're have targets for reducing those scope 3 emissions, because in many cases those dwarf what they would be producing otherwise in their scopes 1 and 2. So we do encourage people to at least look at their top categories for scope 3, especially if they're caught in these regulations, and not to let that go. And there's lots of other things to say about this, about companies that are affected by in the food and beverage sector and other sectors that deal with materials that are affected, products that are affected by what we call the FLAG requirement under the Science-Based Targets Initiative. So, David, do you want to make any comments?
Sure. I'll just, stepping back, on the one hand, folks argue that scope 3 is so speculative, so difficult to assess as to be, again, a shot in the dark. It's unduly expensive and uncertain and things. The opposite side is, as the commenter says, if we don't have scope 3, you are nowhere near an accurate characterization of emissions going into the atmosphere and what we're doing. And so who's right? Yes. They're both true. And so, I think undeniably both are very true. The reality is, if you're under a regulation to disclose them, you're under a regulation to disclose them. And that's frankly I have my own personal views, and when I speak, I say we can go have a beer afterwards and talk about politics and policy and all that kind of stuff. The reality is, if you're doing business in any way, shape, or form that even breathes on California, you need to have a handle on scope 3 and at least a strategy on what you're going to do about it.
Thank you both. Another question from one of our participants. Would you recommend that a company that sells products in the state of California at a minimum prepare the climate report to comply with 261 for the January 1 compliance date?
You know, and I'll jump in on this one, Victoria. First, one, I assume by the question that you hit the threshold, you hit the 500 million. Yes, is the answer. And unfortunately, I do believe that January 1st is going to slide. And if anything, they certainly can't enforce it. For you to expect you to have a complete report of your entire risk assessment for the company for all of 2025 for 26 on January 1 of 26 is just not realistic. But you need to start. And you need to, that's what the law says, and be ready. And when they come and say, you know, we're working on a report, we'll have it to you. I would also note on the side, I deal with a lot of real estate companies and with active construction sites throughout the country. So my point is, it's an ever evolving target. You don't have my personal view, and again, without the benefit of regs going on, I haven't deep dived on TCFD on how they address this. Make a good faith representation of the date certain on which you're going to assess, and assess based on that date. Okay, well, we sold this project, we bought 3 more, we did. That's going to be true throughout your year. And as long as you say, we think this is a representative date, we're going to do all the calculations, all the stuff in a good faith way relative to this date. I'm not telling you they're not going to have an issue, but I think it's the best you can possibly do. So again, pick a date, have a reason why you pick that date as being representative of the year, and then just go full bore relative to that date and don't adjust based on other stuff.
Thank you, David. We also have a question about what our thoughts on whether CARB will potentially accept Scope 1 and Scope 2 reporting by companies for voluntary reporting to the climate registry or other similar entities.
We do. We know that the California Resources Board asked that specific question in their recent public consultation that was put out, and I think the comments were due like by the 21st of March. As long as those particular inventory reports are, if they're verified, for example, that would provide some comfort, I'm sure, to ARB, and I would think that's the sort of thing that was intended in the first place, because of, you heard me talk about all the voluntary reporting that went on before this, and much of it is very rigorous, including the climate registry type system for that reporting. So the short answer is yes, I think that would be adequate. And I'm assuming and hoping that it's been verified, or at least subjected to some sort of auditing.
I think you're going to have some wiggle room given the good faith effort memo, but again, be mindful, Wiener does not like it and does not agree, and so they're going to look for enforcement poster children. I think full speed ahead with a good faith effort of, if you're already doing a regime, spruce it up and do well. CARB will have a very hard time when they haven't even promulgated the regs enforcing a deadline. And I say that hesitantly because I think a lot of people hear that and say, I can coast. I'm not saying that at all. I'm saying pick a notable regime, all of the ones Victoria talked about. Start getting your assessment for 2025 rolling. If the regs come out and they're completely contrary and don't work, that would be very surprising to me, frankly, because this is not uncharted territory. And again, with the caveat of good faith effort and them being so recalcitrant in meeting the legislative deadline for the regs. 261 is a little different because you have a pretty solid TCFD implementation thing, and companies have been doing TCFD for a really long time. And understand the greenhouse gas protocol is not new, but we don't know exactly what CARB's asking for. They haven't, well, the legislature is asking for and told CARB to tell us what they're asking for. And we still don't know. So on what we do know of how this stuff's implemented, jump in on one of those as best you can without too much disruption awaiting the regs. But we don't have an absolute yes until we see the regs, but I agree with what Victoria said.
Thank you both. Along those same lines, there's a question about, and I think you covered this already, David, but what's the potential for delay in that date of January 1, 2026?
On 261, I need to go look. There may be an argument under it was included in Victoria's slide. The follow-up legislation, I don't know that we said it out loud, is 219, 217, 219.
Yeah, we did. We said it.
And they delayed the deadline for the implementation. They sort of reiterated everything that was in there. I didn't see anything clear kicking that. I don't think it was their intention to set a deadline of January 1 for a report reflecting 2025. I think they meant to say the effective date, which would give you arguably 2026, all of 2026, to prepare your report for 2025. That's not what it says. So I think you start moving as best you can, get ready. I do believe, even though it is not what the law says now, disclaimer, I don't see how they can possibly enforce people having to turn in their reports on January 1, but we'll see.
Will we, do you think we'll know in July whether or not that date will get pushed or not?
They haven't hired anybody yet. They're asking for input on what they would like to see addressed, but
Yeah, they talked that they're hiring. I was just at a conference a couple weeks ago with the chair of their resources board and the director for climate, and they said we're hiring. So
yeah,
they're
nothing
setting
to
up
see
the
here.
game.
It's all good. Sure, we're all good.
Yeah.
Okay, another question here. Will, this is an SBTI question, Science-Based Target Initiatives, for those that love acronyms. Will SBTI be modifying or allowing some leniency and lowering the flag protocol? Victoria, I know you spoke to that earlier.
Right.
She's the commenter says that food can't get there because of feed, talking about their supply chain.
Sure. So now the SBTI piece is totally voluntary. We're talking about a voluntary piece here, and we're hoping that that's the case, but it's not. We have this opportunity under their public consultation to review what they're proposing, the SBTI folks, as well as there'll be the flag guidance coming from the greenhouse gas protocol, which has been delayed. So that we need to keep an eye on those and express these types of comments, I think, to people, to those two organizations going forward. So, but the good news is the SBTI is totally voluntary, and there's an opportunity to influence that going forward because they're quite aware of their struggles that they've had, and certainly I am from working with clients in the past, of where the pitfalls are with working with SBTI on especially Scope 3.
I'll just add, for those like me who, prior to my current involvement, had no idea what SBTI was and things like that. I don't mean to disrespect anybody. So SBTI is gained at, once you establish a regime, their certification says that whatever your world is, whatever your economic sector, they believe and certify that what you've outlined as your approach is consistent with Paris, of trying to stay below 1.5. And it's, as Victoria said, it's not a mandatory thing. It's like an extra badge of honor that a lot of people try to go to get the SBTI certification. SBTI has been a little bit under the microscope recently. And so I have all the respect in the world for them. And I think they're very characteristic of a lot of the broader debate, in particular as to your ability to rely on offset credits as opposed to direct emission reductions to get to, again, you're going to disclose your emissions for your emissions, what they are. To get to whether you're consistent with Paris, the question is, can you rely on offsets, and what offsets? They're struggling with that right now. When they announced that they were open to it, some of their certifiers walked off the job because they think it's an anathema. But so SBT, it's an interesting body to sort of gauge both the policy and politics of this whole arena.
Okay, thank you both, David and Victoria. I realize that we're over time now. I'm going to take one more question. If there's other questions that we didn't cover, we'll make sure to follow up with you with the recording, with that question and answer included in that as well. So the last question, I think more of a comment too, is given the political environment that we're in, with the feds moving or seems to be moving to eliminate any kind of climate change mitigation efforts. And then you have states that are looking at basically going at this alone. It's definitely going to create confusion for companies. And so, you know, maybe David or Victoria, you have some thoughts or comments on that.
Go ahead, ladies first.
Well, I think I'm going to punt this to David. I have.
I find the current regime fascinating, frankly, and I'll set partisan arguments aside. I think have a front row seat. I teach on the side as well, and what I tell my students is you have no idea the degree to which you have a front row seat in history right now. I mean, it's truly unprecedented times in scary ways, and other ways, like I said, I don't mean a political statement by that. And I think this is one. And one of the immediate ways I think for private corporate world is chaos. We're seeing a big shift in focus back to traditional fossil fuel energy supplies, less financial support for innovative, renewable things. I think that's likely to continue. And if a business venture is dependent on tax credits, I think that strategy will become very difficult. I think we will see R&D efforts from traditional fossil companies kick into high gear because I think the majority of them know the transition is underway. And even if they have somewhat of a reprieve under drill, baby drill, I think they see what's coming and they have both the resources and the technology to start trying to use this phase to get ahead for whatever's coming next. So I think we're going to see the phrase I use is there's chaos, and in chaos, there's unexpected opportunity. And so I think the immediate stuff is going to be financial. If your corporate undertaking relies a lot on federal money, federal contracting, federal disclosures, expect a very bumpy ride from what you're used to from the past. That doesn't mean there won't be opportunities to forge good stuff. You just may have to be a little more how you characterize what your objectives are and why may look a little different for a while.
Thank you, David.
If that makes
Anything
sense.
else? Anything else, Victoria?
Well, I would just say that with regard to there's a specific executive order that they're referring to about the rollback for, let's say, climate change and greenhouse gas, and we'll wait and see what happens with that and what the lawsuits are and what activities come to pass, because there is a long record in the United States for states having the opportunity to exercise their power to have more stringent laws and even have laws for topics for environmental type protections that the feds don't have. And this has gone on since, well, during my whole career, let's put it, which is a very long time. So this whole idea of states' rights. So we'll see how this plays out, but there'll be lots of opportunities to write articles and books and things going
I'll
forward.
just note, because since Victoria started here and started to chime in before we go off on the politics, and we should have noted this earlier. So what we're seeing, California's cap and trade program, which is a carbon pricing trade program, it's the alternative to an outright carbon tax, has actually fallen on, even in the Democratic power structure in California, has not always been the favored child at the moment in terms of pricing, in terms of scope. It's been a lot. And Governor Newsom was very sort of open on it sunsets pretty soon and whether he went. Well, all it took was President Trump's executive order saying we are going to federally kill all cap and trade programs and carbon pricing programs. And now he being Governor Newsom, the head of the state assembly and the head of the Senate have all taken to the podium and say, we are now resolved to extend cap and trade in California to 2030. They haven't adopted it yet, but they are absolutely committed as of yesterday to doing so. So you'll see a reaction at the state level, particularly in California, to what you see at the federal level.
Okay. Well, thank you again, David and Victoria. Great information, great webinar. Appreciate your time today. Appreciate all the time of our participants as well. Again, if you have any questions or follow-up, we'd be happy to follow up with you. We will be sending out information and links to today's session so that you'll have that information for future reference. From Alabama, I'm hoping y'all will have a wonderful day and enjoy the rest of your week. Thank you.
Thanks, everybody. It was a pleasure.
Thank you.